In 1971, a 15-year-old girl in Indiana was told she was going into the hospital to have her appendix out. She wasn't. She found out what had really been done to her 2 years later, when she got married and couldn't get pregnant. She sued, and the Supreme Court told her there was one person in that story she could never touch. The judge who signed the order. Her name was Linda Spittler. She lived in DeKalb County in the northeast corner of Indiana. She went to public school, and she was promoted every year. On July 9th, 1971, her mother went to see a judge. Her mother's name was Ora McFarlane. She brought a document with her, a petition sworn and drafted by her own attorney. It asked for permission to have her daughter sterilized. The petition described Linda as, in its words, somewhat retarded, a term the document used, not one we would use, and it said she had been associating with older youths and young men. Her school record shows she was passing her grades. The document had one more feature. It contained an indemnity clause, a promise to protect the doctor and the hospital from being sued for what they were about to do. Judge Harold Stump read it and approved it the same day. There was no hearing. Linda was not told. No lawyer was appointed to speak for her. Nothing was entered on the court's docket. The petition was never even filed with the clerk's office. 6 days later, Linda went into DeKalb Memorial Hospital, believing she was having her appendix removed. The next day, she was sterilized. She went home a few days after that with no idea what had happened to her. 2 years passed. She married a man named Leo Sparkman. They tried to have children. Nothing happened. And somewhere in the process of finding out why, Linda Sparkman learned that when she was 15, a court had quietly authorized her sterilization, and nobody had ever told her. So she and Leo sued, and this is the part almost everyone gets wrong about this case. People remember it as the woman who sued the judge. She did, but she didn't only sue the judge. She sued 7 defendants, her mother's attorney, the man who drafted the petition, Judge Stump, 3 doctors, and DeKalb Memorial Hospital. The federal claim ran through a statute called Section 1983, the law that lets you sue when someone acting for the state violates your constitutional rights. Alongside it, she pleaded conspiracy, that these people had acted together. She also brought ordinary state claims, assault and battery, medical malpractice. The federal district court threw the whole thing out. And then, in 1977, the Court of Appeals for the Seventh Circuit brought it back to life. That court gave 2 reasons. First, and this is the one that mattered, no Indiana law gave a judge power to order the sterilization of a girl who was not in an institution, so he had no jurisdiction to sign it at all. And second, even if he had, he threw away his protection by ignoring the most basic requirements of fair procedure. For a moment, Linda Sparkman had won. Then the Supreme Court agreed to hear it. In January 1978, the case was argued in Washington. The newspapers covering it that day described it plainly. A case about a girl sterilized without her consent. The question in front of the court was not whether what happened to her was wrong. Everyone in the room could see that. The question was narrower and colder. Could she make the judge pay for it? To understand what she was up against, you need one old idea. Judges cannot be sued for money over the decisions they make, not if the decision was wrong, not if it was unfair, not even, courts have said, if it was made in bad faith. That rule is older than most of American law. The Supreme Court had spelled it out over a century earlier in a case called Bradley versus Fisher. And Bradley left exactly one crack in the wall. A judge loses that protection only when he acts in, and this is the court's own phrase, the clear absence of all jurisdiction. Not, he got it wrong. Not, he skipped the rules. The clear absence of all jurisdiction, as in, this court had no business touching this kind of case at all. So, Linda Sparkman's lawyers had to prove something very specific. Not that the order was monstrous, that the judge who signed it had no power to sign anything like it. On March 28, 1978, the Supreme Court decided Stump versus Sparkman. Judge Stump won, 5-3. Justice Byron White wrote for the majority. His reasoning was not that what happened was acceptable. It was that Indiana gives its circuit courts a very broad grant of general jurisdiction, the authority to hear essentially any kind of case that isn't assigned somewhere else. The other side had 2 answers to that, and they were good ones. Indiana did have a sterilization statute, but it covered people confined in state institutions, and it ran through a hospital board, not a judge, and an Indiana appeals court had said parents have no right to demand a child be sterilized. The majority worked around both. It read the institutional statute as one route rather than the only route, and it pointed out that the Indiana decision came 4 years after this petition was signed. So, the court did not hold that Judge Stump was right, or even that he clearly had the power to do this. It held something narrower, and for Linda Sparkman, fatal. This was not the clear absence of all jurisdiction. The crack in the wall never opened. The court also set out how you tell whether something even counts as a judicial act in the first place. 2 things matter: whether it's a function normally performed by a judge, and whether the people involved were dealing with him in his judicial capacity. Signing an order the majority held is what judges do, so it was a judicial act, and he was immune from paying damages, in the court's words, even if his approval of the petition was in error. 3 justices did not accept that. Justice Potter Stewart wrote the dissent, joined by Justices Thurgood Marshall and Lewis Powell. Stewart's position was that this was never a judicial act at all. What Judge Stump did, he wrote, was beyond the pale of anything that could sensibly be called a judicial act. And then he described what had actually taken place in a passage people still quote. In his words, "There was no case, controversial or otherwise. There were no litigants. There was and could be no appeal." Justice Powell wrote separately to make the same point sharper. The reason judges are allowed immunity, he said, is that their mistakes can be corrected higher up. But this judge's conduct had guaranteed there was nothing to correct, and no way to correct it. Justice William Brennan took no part in the case, which is how a 9-member court produced a 5-3 decision. It would be easy to leave it there. It is worth stopping on why this rule exists at all, because the people who defend it are not defending what happened to Linda Sparkman. The argument is this: judges decide against somebody in almost every case they hear. If the losing side could sue the judge personally, judges would start deciding cases with one eye on their own exposure. Supporters say immunity is what lets a judge rule against a powerful litigant without fear. Critics say the price of that protection is cases exactly like this one, where the person harmed has nowhere to go. The Supreme Court's answer has been that the correction for a bad ruling is an appeal, which brings you straight back to the hole the dissenters were pointing at. Most people think the story ends at the Supreme Court. It doesn't. The court had answered one narrow question. It said the judge was immune, and it said in a footnote that it was not deciding what happened to the claims against everybody else. Because judicial immunity belongs to the judge, it is his alone. Her mother was not a judge. The attorney who drafted the petition was not a judge. Neither were the doctors or the hospital. So, the case went back down. And in 1979, the entire 7th Circuit, every active judge on it, sat together to finish it. The defendants asked for a clean rule. The judge is immune, so everyone who acted alongside him should walk too. The court refused to give them that rule. Several of the judges said the opposite outright, that a private person can be held liable under Section 1983, even when the judge is absolutely immune, if you allege a conspiracy, and if you plead it with particularity. And that is where her case actually died, not because immunity spread outward from the judge to everyone else, because the conspiracy hadn't been pleaded with enough specificity. The court affirmed the dismissal. The order was unsigned, 5 separate opinions were filed alongside it, and 3 judges dissented, arguing that whether a judge is immune and whether he was acting for the state are 2 completely different questions. There is no public record that Linda Sparkman ever recovered anything from anyone. And that could be where this ends. It isn't. She changed her name to Jamie Renee Coleman. In 2003, she co-wrote a book about what happened to her. In 2007, she sat down with Indiana Public Radio and said it out loud, on the record. And in April of that year, on the lawn of the Indiana State Library, the state dedicated a historical marker to its own 1907 eugenics law, the first law of its kind in the United States. Jamie Renee Coleman was there. She helped unveil it. So, can you sue a judge? For a ruling essentially never. Absolute immunity covers judicial acts, and it survives being wrong. The narrow exception is the clear absence of all jurisdiction, and it is narrower than it sounds. This case is the proof of how narrow. What does exist? Where there is a live case, a ruling can be appealed, though as this case shows, that assumes there was a proceeding to appeal from in the first place. Separately, every state has a body that handles complaints about judges, and there is a federal process for federal judges. Both can discipline a judge. Neither pays you anything, and neither undoes the order. And the thing most people get wrong is worth holding on to. Immunity protects the judge. It does not protect everyone else who was in the room, as the Seventh Circuit said out loud, even while it was ruling against her.